Today, we're diving into the official rulebook for civil justice in India, the Code of Civil Procedure. Now, I know what you're thinking, 1908. That's old. But believe it or not, this document is still the playbook that guides a lawsuit's entire journey, all the way from a simple disagreement to a final binding court order. So let's trace that journey together.
You know, we've all thought about it. That business deal that goes sour, a promise that gets broken. These kinds of civil disputes happen every single day. And when you just can't work it out by talking, where do you go? How do you get a fair resolution?
Well, the answer is right here, in the Code of Civil Procedure, or what lawyers call the CPC. And seriously, don't let that 1908 date fool you. This isn't some dusty old book. Think of it as the operating system for our civil courts. It's the system that makes sure every fight is handled in a structured, predictable way. It prevents total chaos and gives everyone a fair shot.
The way the code is built is actually pretty clever. It's split into two main parts. You've got the sections, which are like the big core principles, the what the court can do. And then you have the orders, which are the nitty-gritty, step-by-step rules of the game, the how you actually do it. This setup is brilliant because it separates the fundamental ideas of justice from the day-to-day mechanics of the courtroom. Okay, so you have a dispute. How do you actually get the ball rolling and take it to court? This first part is absolutely crucial. You have to start the right way, in the right place, because if you mess this up, your case could get thrown out before you even get to make your argument.
So, the very first question you have to answer is, where do I file this thing? The code has a simple name for this, the place of suing. It's not just about what's convenient for you, it's all about fairness. The rules make sure that the lawsuit is filed in a court that has a real, logical connection to the problem or the people involved.
And check this out. This is an example taken straight from the code itself. It makes it so clear. If the incident happened in Calcutta, B can sue there. That makes sense. But because the person who did wrong, A, lives in Delhi, B also gets the choice to file the lawsuit there instead. The power is in the hands of the person who was wronged, giving them a fair and practical path to justice.
So let's just quickly recap those first moves. Step 1, figure out the right court using those place of suing rules we just talked about. Step 2, you have to write up a document called a plaint. This is basically your formal written complaint. And step 3, you officially file that plaint. The moment you do that, your lawsuit has officially begun.
So what exactly is a plaint? Think of it as the opening chapter of your legal story. It's the document where you lay out your whole case. You have to clearly state who you are, who you're suing, what happened, and, this is the most important part, what you want the court to do about it. That's called the relief, whether it's money, getting your property back, or just making someone stop doing something.
All right, the lawsuit has been filed. The first move has been made. Now we get into the main event, where both sides get to make their case. The court's main job now is to find out the truth, and the code lays out the strict rules of engagement for how that's supposed to happen.
The very first thing the court does is send out something called a summons to the person being sued. Now, this isn't just a friendly invitation to pop by the courthouse. It's an official legal order. It tells the defendant, hey, someone has filed a lawsuit against you, and you are legally required to show up and respond. This is Justice 101. You have to hear from both sides.
So you have the plaintiff's story in the plaint, and then you have the defendant's formal reply. When you put those two documents together, you get what the law calls pleadings. These documents are so important because they basically draw the battle lines for the entire case. Everything that happens next, the evidence, the witnesses, the arguments, it all has to relate back to what was said in these first documents.
So how does the court actually figure out who's telling the truth? It's not just a guessing game. It's a very clear step-by-step process. First comes discovery, which is when both sides have to show their cards, so to speak, and exchange all their documents. Then the court frames the issues, which means it pinpoints the exact things the two sides are disagreeing on. And finally, witnesses are called in to tell their stories under oath. Every step is designed to build a clear, factual picture.
So after all the documents are in, all the witnesses have spoken, and all the lawyers have made their arguments, we finally reach the moment of decision. This is kind of the climax of the whole journey. But as we're about to see, the story isn't always over just because the judges made up their mind.
The first thing the court gives is its judgment. The easiest way to think about the judgment is that it's the why. It's the judge's detailed explanation of how they looked at all the facts, applied the law, and came to their conclusion. It's all about transparency and showing the logic behind the decision.
Okay, so right after the judgment, which was the why, comes the decree. And if the judgment is the why, the decree is the what. This is the official, final order from the court. It's the bottom line. It's the part that says, you must pay this amount of money, or you must hand over this property. This is the legally binding outcome of the whole case.
And this is the million-dollar question, right? A court order is great, but it's really just a piece of paper unless you can enforce it. So what happens if the losing side just shrugs? What if they just ignore the decree and refuse to do what the court ordered?
Well, this is where the code really shows its teeth. There's a whole section called execution, which is all about enforcing the court's decree. And let me tell you, the court has some serious power. It can seize and sell the losing party's property to make things right. And in some pretty extreme cases, it can even issue a warrant for their arrest. So yeah, a decree is definitely not a suggestion. It's a command with very real consequences.
But you know, even with that final order, the process isn't necessarily over. The system has to have checks and balances, right? That's why the code has a whole process for appeals. If one side truly believes the judge made a mistake with the law or the facts, they can take their case to a higher court to get a second opinion. It's a crucial safety net.
So we've followed this entire journey, all the way from a small disagreement to a potential appeal. Let's just take a step back and ask the big question. Why does this rulebook from over 100 years ago still matter so much?
It matters because without it, we would have absolute chaos. The Code of Civil Procedure gives us a peaceful, predictable, and open way to solve our problems. It ensures that justice isn't about who's stronger or who's richer, but about who has the better case based on a set of rules we all have to follow. It's literally the engine that turns chaos into order.
And all of this leaves us with one last, really big question to think about. Our world today, with digital fights that can cross borders in a second, is completely different from the world of 1908. So is a rulebook from back then really equipped to deliver fast, fair justice for the kinds of problems we face in the 21st century? That's something worth pondering.